Good afternoon, everyone. Welcome and thanks for joining our webinar today, focused on tools for, the nuts and bolts of farmland leasing. This webinar is brought to you by New Entry Sustainable Farming Project and by Land for Good, and is made possible by generous support from the Northeast Extension Risk Management Education Center. Our webinar today is going to run about an hour and 15 minutes. We're going to start today with a quick technical orientation and an overview of New Entry Sustainable Farming Project's mission and programs. Then we'll dive into the meat of the webinar, starting with Kathy Ruhf, who is the Senior Program Director at Land for Good, and we'll be talking about the benefits of farmland leasing, elements of a good lease, and different types of leases. After that, we'll hear from Elena Mihaly, who is an attorney and legal fellow at the Conservation Law Foundation. Elena is the coordinator of the Legal Services FoodHub at the Conservation Law Foundation, and she will be discussing when it's appropriate to consult a lawyer and when to expect what to expect when engaging legal services for help with farmland tenure. I'll then do a very brief discussion of some different things to think about when looking for the right fit with a potential landowner. We'll end with about 10 minutes for a question and answer session. So let's get started. So that's all for the tech orientation. Now I'd like to tell you just a little about New Entry Sustainable Farming Project and why we are hosting this webinar. So New Entry is a nonprofit organization. We were founded in 1998. Our mission is to improve our local and regional food systems by training the next generation of farmers to produce food that is sustainable, nutritious, and culturally appropriate, and making this food accessible to individuals regardless of age, mobility, ethnicity, or socioeconomic status. So in doing this work, we provide training, career development, and economic opportunity to new farmers. Our programs include a farm business planning course, a farm training and incubator program, and the World Peas CSA, which aggregates produce from beginning farmers for sale to hundreds of CSA customers throughout the greater Boston and Lowell, Massachusetts area. We also organize livestock field schools, manage a mobile poultry processing unit, and run a farmland matching program, which is the host of today's webinar. So New Entry's Farmland Matching Service assists farmers with locating, evaluating, and matching farmers to farmland in Massachusetts and the surrounding region to a certain extent. On the other side of the coin, we also work with landowners who would like to see their land farmed by helping them understand the basics of farmland leasing and helping them find the right farmer and farm business for them and for their land. The Farmland Matching Service also works directly with communities and municipalities to help identify unused viable farmland, reach out to farmland owners, and in general increase active agriculture in many communities throughout Massachusetts. One last thing I'd like to point out before we move on to today's webinar is that New Entry has a number of resources in our Farmer Resource Library online. You can see the link at the top of the slide here. This includes written guides on multiple plot farming, finding, assessing, and securing farmland, as well as the use of GIS mapping for discovering underutilized farmland. Great, so without further ado, I'm going to turn it over to Kathy Ruhf to talk about farmland leasing. And 1 second, Kathy, and I will give you control.
All right, can you all hear me?
Yes, perfect.
Great, okay, well, good afternoon, everybody. Thanks for taking the time to join this webinar. This focus of my conversation today is on the nuts and bolts of farmland leasing. Land for Good is an organization that specializes in farmland access, tenure, and transfer, all the ways that farmers can get onto land, hold land, and pass it on either from one generation or one owner to another. Similar to New Entry, we do help farm seekers acquire land. We do a lot of work on lease agreements, and we also work with landowners and exiting farmers to make their land available or pass their farms on. So let's talk today about lease agreements. The basics in terms of farm leasing, even before you're ready to lease, I hope that most of you will take the time to really understand what all of your options are and to make yourselves ready to enter into a lease agreement if that's the best choice for you. What you need for farmland, as you well know, is access, which means more particularly that the land needs to be available to you. There needs to be enough of it, and you have to be able to get to it and get on it and use it in the ways that are appropriate for your particular uses. And it has to be affordable, which isn't the same as cheap. Cheap land. It means that you have to be able to afford it as part of your business and family finances. So there are ways to make land more affordable. It's a different subject, but just to understand that affordability is a little bit of a complicated concept. You obviously need security. If you own the land, you have as much security as you're able to have within the confines of local and state regulation. If you don't, then security is a much bigger issue, and the terms of a lease will provide you greater or less security. Part of security is, of course, how long the lease runs. The longer, the more secure you feel. But there are other provisions in a lease that also contribute to or undermine your sense of security on land that you don't own. Equity, to me, means two different things. One is the clear and equitable division of rights and responsibilities, and I would also add the benefits of being a user on that land. And there's no better way to be clear about that division than through a lease contract. Equity also means sort of thinking through the ways to build equity, and that's one of the biggest concerns that many farm seekers point out, is that if you're not on land that you don't own, if you're not on land that you own, that you won't be able to build equity in that land. That is true. However, a colleague of ours at Farm Credit has crunched some numbers and showed that the same farm business, if it were on rented land compared to land that it purchased at market value, the net return to family living is 5 to 6 times greater if you are renting the land. If you buy conserved land, the difference isn't that dramatic. But the point is that you are gaining more in terms of net return that you might consider building equity in other ways. So it's not just, it's a little bit more nuanced about the relationship of equity and land tenure. So the benefits of leasing, as I've mentioned, is for one thing, it is more affordable, and it may be the only thing that you actually, the only strategy that you can afford, especially if you're starting out. Leasing gives you more flexibility to test either the idea of farming in the first place, the kind of enterprise, the kind of market, the location, the community, the method of farming, and it doesn't tie you quite the same way as if you actually invest in a piece of property. And leasing can definitely be a path to ownership, which is very attractive to many farmers, especially those starting out, where you are maybe leasing the only land that you will hold, and it may actually be your home as well. So let's touch on a little bit types of leases. The basic types are a short-term lease, which can be annual, up to maybe 2 or 3 years would still be considered a relatively short term. Most leases in this country are annual, and in fact, most of them are handshake. In other words, they're not written down, which is has a long custom in many farming communities, but typically is not advised. It's advised that you should always have a lease, especially, a written lease, especially if it is longer than a year. A rolling lease term is sort of a variation on a lease, sometimes called an evergreen term, where let's say you have a lease term of 3 years. At the end of the first year, you have another 3 years. At the end of the second year, you have another 3 years. So essentially that 3 years is continually rolling over. It gives you a little more security than a lease that would absolutely terminate unless it was renewed after 3 years. Longer-term leases can be 5 years, 10, 20, 50, up to 99 years. And although 99-year leases are not super common in the private sector, they do exist, and leases can be inheritable. A ground lease is a really interesting hybrid. If those of you who are interested wish more information, I refer you to Equity Trust, which is an organization that has done a lot of pioneering work on agricultural ground leases. Quite simply, a ground lease is where you rent the ground or lease the ground from the landowner, but you purchase or build and own the structures on it, most typically a house and sometimes the agricultural structures as well. So it's more affordable because you're only buying the buildings and not the land. Typically, a ground lease is up to 99 years, so you have the long-term security of knowing that you'll be on that land, and you're building equity in the improvements such as the house and barn that you own. And then, as I mentioned, leases can, a short-term or a long-term lease or any variation, can build in provisions toward ownership, either with an option built in or a right of first refusal. So what is a lease? A lease is a legal contract, and Elena might be speaking to this a little bit later in this presentation. A legal contract is made legal by having the 5 elements listed there. Quite simply, the parties, who they are, the landlord and the tenant, and those need to be the official legal representation of what those entities are. A sufficient description of the property. And sometimes on more complicated properties, it's really advised to have an attachment to the lease that has maps. It might also list the condition of the land and structure, such as fencing and so on, at the start of the lease in order to document either improvements or needs for repairs. The term, which is to say the start and end dates, and what's called the consideration, which is the rent or other fees. And even if it's 0, it needs to be identified in the lease contract. And then finally, the signatures of the parties that were identified in the lease. So you can see that for a simple lease, it could be completely accomplished in less than a page. However, most of them, have a little bit more detail, and that's where the devil is. And it's quite typical to have other kinds of conditions, which we're now going to go into. So what's in a lease? We're going to go through a somewhat extensive laundry list. The provision for extension or renewal is just a slight difference. An extension is where you just extend the terms as is, and the term of the lease just goes out further. A renewal is essentially where the lease terminates and is renewed over again. And in either case, there's the opportunity to make changes that are mutually agreeable. Termination is a really interesting and important section of a lease. You certainly want to be able to have exit strategies and understand what your obligations are as a farmer if you plan to terminate early. Legally, and perhaps Elena will speak to this as well, you could conceivably be held liable for the payments of the unexpired portion of your lease. That doesn't often happen, that farmers are brought to court on that, but it is something that you need to understand. If the lease is well written with your interests in mind, it will allow you an exit, but provided you provide sufficient notification, and you might have to return some of the land into its former condition or put cover crops or whatever. Exit for the landlord, by comparison, shouldn't be quite as easy as giving notice. For example, if you have a 10-year lease, but there's no termination provision that says to the contrary, the landlord could give notice, give you 6-month notice, which essentially means that you have a 6-month lease or a 1-year lease. So that the termination provision absolutely has to be consistent with what you're assuming is the security of the term of the lease. If you have a clause in your lease and the lease is recorded, the lease will stay with the land. That often comes up as a question, whether if the land is transferred from one owner to another or the owner dies, what happens if the heirs want to sell? You can have that additional security by noting in the lease language that the lease does stay with the land. There are always notification procedures, which party needs to give notification with how much advance notice, which notifications need to be in writing. And those kinds of things are important for maintaining the clarity of the relationship, regardless of which section of the lease. So the section on permitted uses is important because people have different understandings of what constitutes agriculture or an acceptable practice or an acceptable enterprise. Are the woods included? Is chopping down trees allowed? Is aquaculture allowed? Is on-farm processing allowed? Are farm tours allowed? Is on-site pickup allowed? You have to get pretty specific, but of course allow for flexibility, so you don't want to get too down into the details on that. And I'm always fascinated by the language details in a lease, and the difference between may versus shall is an example. You know, shall is a requirement and may is optional. So if you are in the process of writing or considering thinking about drafting a lease, think about language details, because that's where the legal rub often is. As much as it's important to specify permitted uses, it's also really important to clarify what are prohibited uses on the farm, and landlords really vary with respect to how detailed they are about prohibited uses. Typical sort of generic boilerplate kinds of prohibitions are, you know, mining for minerals, or removing topsoil, or chopping down trees without, or clearing without prior permission. But sometimes landlords are pretty particular. They may not want any livestock. They may not want you to park your farm vehicles in a certain part of the field. They may not want you to put build with certain kinds of materials. So that's important to be clear and part of the ongoing relationship with the landlord. And again, to be really clear about the permission and approval process. Even if something is permitted, you might need, or it might actually be a good idea to check and get the landlord's approval. So moving along. The rent is a really interesting consideration. It's probably one of the most commonly asked questions. How does rent get determined, and what are the ways to pay the rent? There are basically several ways to pay rent. The most straightforward is a cash rent, but there are other ways that particularly engage the landlord in taking on a little bit more of the risk. A share lease is where the landlord and tenant actually divide what it is they bring into the relationship, and that the landowner then also extracts a portion of the return. In the Midwest, it's often in the form of the actual crop. Here, it's less likely to be the crop and more likely to be a percent of a profit. A flexible cash lease is sort of a hybrid where there's a floor rent that's determined that's below the market value, and also adds on a share component. So in a good year, the farmer will pay the floor amount plus a percent of the profit. In a bad year, the farmer will only pay that floor amount, which is lower than the market value, and the landlord doesn't get any additional benefit. Sometimes there are non-cash considerations in addition or instead. For example, a CSA share, or some cordwood, or some services like clearing or maintaining trails. Those need to be documented for the benefit of both parties. So they need to actually be monetized and figured into what the landlord is receiving. When and how to pay can be annual, can be monthly, and again, there are variations that both parties work out. Calculating the rent, you'll see at the bottom of this slide, I've given you a really good resource that's put out by the University of Vermont. It's really probably the seminal work that I've seen on ways to determine the rent. Quite quickly, there's the market rate, which even there, it isn't that easy to determine. It can fluctuate. It really varies from area to area. It depends on a lot of factors, including competition from existing farmers. USDA does maintain a database of average rental rates for irrigated and non-irrigated cropland and also pasture land, but it doesn't cover every county. It typically focuses on ag-dependent counties, and many of the counties in New England aren't covered by that. Sometimes the landowner is most interested in recouping his or her costs, which are sometimes referred to as the Dirty Five, which stands for depreciation, interest, repairs, taxes, and insurance. So that's depreciation, interest, repairs, taxes, and insurance. Oftentimes the landowner will be happy to have the rent cover the property taxes, and in some cases the fact that the land is used for agriculture will give the property owner a preferential tax rate that is so much better than what they would be paying at full property tax rate that they don't actually charge the farmer an additional rent. So it's good for you all as prospective or fledgling tenants to make sure that the landlord understands that there is a property tax advantage to having their land in active agriculture. Each state has its own preferential or current use tax regulations, and there are qualifiers to it. A certain amount of income needs to be demonstrated to show it is a viable, or show it is in commercial use, and also there are acreage thresholds. Sometimes the production capacity, such as the soils and other natural factors, are the determiner or a determiner of rent. And also that the rent can be influenced, as I said, by landlord social goals. I've worked with landlords who have given either a sliding scale or subsidized or a really favorable rent terms in other ways because they want to get a beginning farmer going or because they believe in local food and so on. So it's really good to understand where your landlord is coming from and to capitalize on those interests. Okay, moving along. What else is in a lease? Well, this is a section, or these sections come up a whole lot as well, especially in longer term leases and where there are buildings or other kinds of improvements involved. Repairs and maintenance is an important clause. There's some guidance in several publications that will tell you, explain the difference between a routine repair and a capital repair. And typically a tenant is responsible for routine maintenance and minor repairs, and the landlord is typically responsible for major repairs. But again, the lease is a contract that can be negotiated however the two parties wish, provided they're not violating any laws. I've seen complicated formulas wherein both parties sort of agree to a proportion or a threshold, or the tenant will pay for a certain capital repair and the landlord will pay for another one, so it really does vary. Capital improvements depends on if it's permanent or severable. A permanent improvement, you can have language in, especially around a longer-term lease, that the landlord could buy back the undepreciated value of that improvement. The tenant could sell it to the next tenant. There are various strategies to deal with improvements on a property. That said, a typical concern and well-grounded is that if you do invest in an improvement, you're not likely to get that back. So if you can't take it with you, what is the formula for, or what is the possibility for realizing some of the value of that improvement, or else understanding that you'll just be depreciating it as a working asset over the life of your lease. Insurance and liability is a landlord concern as a tenant concern. It's not unexpected, and it's quite typical for a landlord to require the tenant to have show evidence of liability insurance, and that can be $1 million per occurrence or $2 million aggregate, which doesn't cost that much to buy that policy, and typically the landlord or landowner is named as a co-insured. Typically, the landlord provides casualty insurance, and then it's up to the tenant if you want to insure your possessions as well. The landlord has no responsibility for your personal possessions that are not attached to the property. Default is an important provision in a lease. It's much more common to see a lot more language about tenant default than there is landlord default, but certainly anything that you do that violates the terms of the lease you're subject to default. That doesn't mean that you're automatically kicked off. Your lease should provide for a procedure for being notified. So for example, if you are leaving your equipment in a field where your lease says you're not supposed to leave your equipment, the landlord would notify you and give you 30 days to remove the equipment or whatever the request is. And that's called curing the default. If you do not, then the landlord has the right to terminate the lease. Landlord default is a little bit harder to define, but there are clauses in the lease that specify a landlord's obligations, such as routine maintenance, and theoretically you have the opportunity to pursue your landlord for default on any of the provisions that they are not adhering to. Leases do often have a clause in them about resolving conflict. It doesn't have to go to the level of formal mediation or arbitration, but it is good to have a section in there that says, you know, if you don't come to agreement, how you're going to try to resolve things and possibly bring in a third party to facilitate an understanding. Often I hear from folks who they say, well, we don't really need that, we get along so well, we love each other and so on, and that's all true until the first time the well pump breaks and it's not super clear who's responsible for fixing it. Many landlords are really concerned about how their land is managed, and rightfully so. So the stewardship standards and provisions in a lease, they may be contained in the body of the lease, or they may be referenced as a separate attachment. There is guidance on this in several documents as well, which I'll talk about at the end. I think in general, to understand the difference or the nuance between a stewardship principle, which is sort of the overarching values that probably the landowner and the tenant share about the quality of the soil, about protecting habitat and water resources and so on. Those can then be broken down into more particular goals and further into practices. You don't necessarily want a lease that specifies your practices. You don't want a document or a landlord telling you that you should be, you know, farming across the slope or having a 10-foot riparian area or whatever. You want to be able to determine those practices and demonstrate to the landlord that they meet the principles that the landlord feels are most important. And as I said, it's probably a good idea to attach those plans. You might have a conservation plan, you might have an organic certification plan, you might have a holistic management plan. Whatever it is, it's important that those be referenced. They're easier, much easier to change than the actual language of a lease. If you are contemplating or on a property that also includes a residence, you may be advised to have a separate lease for that, because there are pretty clear state laws with respect to tenants' rights, and there are particular templates for residential leases. Sometimes farms are leased as a whole, and there's nothing wrong with that, but just to understand that you do have that option, and there may be certain circumstances where that's a better idea. Farm buildings are, if they are included, it's not that easy to find the good advice on the rental rate. That UVM publication does have a section on that as well, so it is a little challenging to figure that out. It depends on the condition of the building and its usability and so on. I did talk a little bit about change of landlord. If you have written the lease carefully, that should not impact you, although when it comes time for renewal, you know, the landlord, if the landlord has changed, he or she may want to inject some new provisions. The lease, especially longer and more sort of complex leases, will probably say something about subleasing or assigns. In other words, if you are in fact allowed to sublease to somebody under you or to assign the leasehold interest to somebody else. Typically, a landlord, if they do allow that, would not allow it without approving of the sublessee or the assignee. So that was a really quick trip through some of the basic clauses in a little bit more complicated lease beyond the 5 elements that constitute a lease contract. There are, as I said, a lot of resources out there. Land for Good has bunches of them on our website. We do have an online tutorial that sort of walks you through all of the topics related to acquisition of a farm through lease or purchase. We have a separate leasing tutorial. We have several lease examples and templates, and we also provide a bunch of one-on-one consultation with field agents in every state. Our website also has a toolbox for farm seekers and for landowners with our own publications and links to a lot of other organizations such as New Entry and other groups as well. And we do a lot of workshops and mixers. So let me see if that's my last slide. So there we are. There's our field agents in each state. Our web address down below in which you will find more detail about our field agents. And you can also visit us at info@landforgood. So I think that's my last slide, Noelle. Yep. So I'll pass the baton.
Great. Yeah, you can pass that over to Elena. So I just want to reiterate that if you have questions for Kathy or any of us during the presentation, feel free to send them to me in the chat window at any time, and we'll address them at the end. All right, so I'm going to turn it over to Elena of Legal Services FoodHub. To discuss engaging legal help with respect to land tenure. Are you there, Elena?
I'm here. Can you hear me?
Yep.
Great. Well, thanks everyone for joining, and thank you, Kathy, for that illuminating presentation. I'm glad you went first so that I can modify mine appropriately. So I am not seeing my first slide. Noelle, can you see it?
I'm passing the ball to you right now. There you go. You should have control.
I think I'm still not seeing my slides. Sorry.
Can you navigate over to your slide? You have control. You should have control of the slides now.
I'm not even in full screen. I'm still.
All right. Let me see if I can. I'll take it back and see if I can navigate over.
There we go.
Oh, I just took it back. All right, hang on one second.
Okay, I see that I am now the presenter. Great.
Great.
Okay, so again, my name is Elena Mihaly. I'm an attorney. I work at Conservation Law Foundation, and Noelle asked me to join this webinar not so much to talk about the nuts and bolts themselves, as Kathy just went over, but more to talk about how you may want to think about engaging legal help when you're drafting this lease and what to expect when you're consulting with an attorney. So I'm just going to take about 15 minutes. First, I'll talk about Conservation Law Foundation, my organization, and then I'll talk about when and why it might be a good idea to consult a lawyer for land transactions, what to expect in terms of the questions that they may ask and the cost to you. And then I'll wrap up with talking about the Legal Services FoodHub, which is a great new resource at Conservation Law Foundation where we partner farmers with free legal advice for all kinds of transactional legal issues. And then I'll just give you some legal resources at the end. So Conservation Law Foundation is a New England-based environmental advocacy organization. We use the law and policy to protect the environment for all people, and we believe that a resilient agricultural economy is good for the environment. So through our Farm and Food Initiative, we work on law and policy issues that foster a robust New England food system. One thing that we noticed is that oftentimes farmers are not actively seeking legal assistance with an attorney for a lot of the transactional issues that they're facing. This is a statistic coming out of Farm Commons in the Midwest, but of surveyed farmers, only 10% of them use legal services, compared with 70% of small businesses that did so. And this is problematic given that farmers are facing a lot of the same decisions as small businesses in other industries, such as entering into leases, negotiating sales contracts, entity formation questions, just to name a few. So we wanted to start working, since we're a bunch of lawyers and we work on farm and food policy issues, we wanted to start addressing this issue and trying to plant the seed that sometimes consulting with an attorney can be really great for establishing a viable business. So what we've been doing is participating in educational workshops such as this, just to raise awareness in new and beginning farmers and longtime farmers that sometimes considering consulting an attorney can be a great idea. We also started this new project, the Legal Services Food Hub, which is a pro bono legal services matchmaking project where farmers can seek free legal assistance. I will talk about that at the end of my presentation. And then lastly, we've been working to empower the legal community to use their existing skill set to assist with farmers' legal needs. So maybe a corporate attorney who's never worked with a farmer before but could really help a farmer work on their entity formation issues. We've encouraged them to use some of their pro bono time to work with farmers. So involving an attorney. I'll hone in on leases here since that's the gist of this presentation. And I just want to clarify some lease basics. So a lease is the right to use someone's land. A lease can be either verbal or written. And it's important to remember that the document, like an actual piece of paper, is actually evidence of the lease. But the lease itself is the contract or agreement, so it can be oral or written. Obviously, and as I'm sure you've heard, a verbal lease, while more traditional, is more risky because it's difficult to enforce, especially ones that last longer than a year. And it's important to write down a lease for a number of reasons. One, it's enforceable in court, whereas an oral agreement isn't. Typically, there's just not enough evidence to support it. And it can preserve community relationships. You know, memories are fallible, and just because, as Kathy said, you're best friends with the landowner when you made the agreement, as soon as something goes wrong, it's really nice to have a document to go back to so it doesn't just turn into a big he said, she said. And lastly, the process of writing a lease down helps you think of contingencies that you might not have otherwise thought of had you just had a conversation over a cup of coffee with the landowner. So why would you want to think about engaging a lawyer? Well, lawyers are trained to help memorialize things that are said out loud orally and write them down in concise and accurate language so that that document can then be enforceable later. Lawyers are trained to see where terms might actually be ambiguous, and they will help you really narrow it down so there really can be no room for different interpretations. Lawyers can also help you foresee those possible contingencies or areas of conflict that you might have not seen yourself. A skilled real estate lawyer has been doing this for a long time, and it's really nice to find one that has worked with farmers before because they have the wisdom of doing this over and over again and can help you see contingencies where you might have not seen them. Finally, lawyers can help you brainstorm creative solutions to sticky issues that form leases don't contemplate. Form leases are a good place to start to get you thinking and get ideas going, but unfortunately, a lot of the agricultural form leases that are out there don't contemplate the sorts of diversified farming operations that are often taking place and that many of you may want to pursue. So it's a good place to start, but lawyers can help you then tease out those forms and make it specific to your case. In terms of what to expect, I just put down a bunch of bullets of questions that the lawyer might ask you in that initial meeting, for example. And I'll spend about 5 minutes going through these. Kathy went through a lot of these, and again, I don't want to focus so much on the content, but more thinking about, you know, picture yourself in a meeting with the lawyer. These are the questions that the lawyer is going to ask you. In terms of the basics, as Kathy said, they're really going to want to know who are the people that need to be the ones that sign that lease. If your landlord is acting in their personal capacity, or are they acting on behalf of a business, such as a farm LLC, and if so, do they have the authority to be signing that lease? Or if there's a spouse, does the spouse also have to sign that lease? Also, in terms of where, as Kathy mentioned, the lawyer is going to want to have a really precise legal description of the land. A map of the premises would be really helpful to bring into that first meeting. The rental payment, there's a lot of different options. Again, how it should be paid. Is there going to be a late payment fee? The rights, what rights does the lease grant to the farmer? That, again, goes to whether this lease is going to allow the farmer to engage in any commercial use of the property, or is the lease going to be limited to agricultural use of the property? And harking back to what Kathy said, the way that agriculture is defined in that lease is really going to make a huge difference in what is allowed, because a landowner may think, oh, I'm leasing to a farmer. This is going to be, you know, farming is quiet. They're just out there picking weeds and planting, and it's going to be peaceful. But then CSA day comes, and there's lots of cars and kids running around, and it's anything but. And so knowing in advance what kind of use you want to make of the property and making sure that you define agricultural use to include that use in the lease is super important. Production-related issues, that's, again, I don't want to reiterate, but that's where you would want to have the land stewardship principles that are important to you or the landlord. Facilities, the lawyer is going to want to make sure that there's very clear indication over whether the farmer has access to farm equipment or resources that are on the land, and who fixes it if there's a problem. Renewal, Kathy went over. Communication, this is key in terms of avoiding conflicts. A lot of lawyers would advise farmers to have a provision in the lease that requires a quarterly meeting with the landowner, for instance, or maybe meetings that are triggered by certain events, just to keep that line of communication going. And give the farmer an excuse to meet with the landlord on occasion. Transfer of the lease, again, what happens if the landlord dies? Most farmers will want to make sure that the lease still attaches to any future landowners, so the lease should state as much. Insurance, Kathy talked about. I had a inquiry to the Legal Services FoodHub last summer. There was a farmer who had planted a whole field of garlic, and just as she was going to harvest her crop, her landowner accidentally plowed her entire crop of organic certified garlic. And her landlord had insurance, but there was nothing written in the lease about whether the insurance would pay for that kind of incident, and if so, whether the insurance company would provide her with the cost of just, you know, reimburse her for just the cost of normal garlic, conventional garlic, or whether she was going to be reimbursed for the organic value, which was a big difference. So those are the kinds of issues that it's helpful to have maybe a lawyer come in and tell you some horror stories of things that they've heard to make you aware of, like, oh, that's something that I should maybe write into this lease. Right of first refusal, Kathy talked about this. Again, if that's something that you're interested in, you'll want to make sure it's in the lease, and not only that you have that right, but that you put in a clause about how the land will be valued. Managing potential future conflicts also can be done in the lease, and as Kathy said, there's sometimes dispute resolution clauses. One interesting idea I heard of lately is the farmer and landlord establishing a dispute resolution committee where the farmer nominates someone and the landlord nominates someone, and then those two people nominate a third neutral party, and together those three serve as the dispute resolution committee should any disputes arise between the farmer and the landowner. And obviously that's not whatever pathway to resolution that committee suggests isn't binding, but it's nice that protocol is in there as sort of a first line of defense, because enforcing lease breaches can be lengthy and, in court, can be a lengthy and costly procedure, unfortunately. Suing in small claims court is, it's relatively straightforward, but it requires really good evidence. It's no easy task. So having this dispute resolution committee can be a nice first line of defense. And finally, who is responsible for large-scale capital improvements to the land? Again, for instance, if there's an access road or something, you want to make sure the lease really clearly says who's responsible for maintaining that, or the cost shared, etc. So that's not an exhaustive list, and I'm not an expert in terms of crafting the actual lease, but these are just questions I've heard lawyers want to know the answers to when they're meeting with farmers and talking about farmland leases. This is a question that is on everyone's mind of how much it's going to cost, and I wish that I had a single answer for you of like, it's going to cost you X number of dollars to write a lease. But the truth is that the combination of every lease being very different and every lawyer having different rates that they charge, I can't give you just one number. Lawyers' hourly fees really differ from like, I'll do it for jars of tomatoes all summer to I'll do it for $1,000 an hour if you're at some hotshot firm in Boston and it's a partner. But I will say that the more groundwork you do, the more you have met with your landlord beforehand to discuss answers to all the questions raised by Kathy and myself, the lower the cost will be, because the less time you'll have to spend with the attorney. I'll also say that the more unique relationships are going to make, it'll take the lawyer more time to wrap their head around it. So if there's sort of a complex situation where there's a bunch of sub-lessees and they're all sharing a common area, and that could be just take longer for the lawyer to understand. So maybe that would be more expensive. But you should expect that your attorney will give you a cost estimate at the beginning in that first meeting. It's totally reasonable, and you should expect that a lawyer would be able to anticipate at least a rough amount of how much it would cost. And it's absolutely reasonable to politely inquire whether the attorney would be willing to charge a discounted rate to farmers, or even do some bartering if you're lucky. So lastly, I just want to talk about the Legal Services Food Hub, which is a new project of Conservation Law Foundation. Our mission is to provide pro bono legal assistance to farmers, food entrepreneurs, and related organizations in order to foster a sustainable, resilient, and just food system. Essentially, this is a matchmaking project. So farmers can call us with any of the listed transactional law issues here. You'll see that land acquisition and farmland leases is on there. And we will assess you for eligibility and endeavor to match you with one of the attorneys that is in our network. So it won't be an attorney at CLS. These are attorneys that are at law firms around the state of Massachusetts who have agreed to designate some of their time pro bono to help with this project. We do have income eligibility criteria. Just because this is a free resource, we need to make sure that it's going to folks that wouldn't otherwise be able to afford an attorney. I'm happy to answer questions about these. They're also available on our website. The hub, as I mentioned, is currently located in Massachusetts. That's where we're doing our pilot year. However, we are expanding to Maine in the spring and Rhode Island in the fall, so stay tuned for that. In terms of reaching the Legal Services Food Hub, you can either submit an online inquiry on our website. Here's the address, legalservicesfoodhub.org, or you can email us or give us a call. Any way you contact us, I'm the coordinator, and I will reach back to you, and we'll have a conversation about what your legal issue is and whether you're eligible related to income, and then we'll endeavor to match you with an attorney. So here are just a few additional legal resources. As Kathy mentioned, I mean, Land for Good has a bunch of really great toolboxes for leasing farmland. Farm Commons has this really great resource, Drafting a Lease, Questions for Farmers and Landowners to Ask. I highly recommend taking a look at that. And then there's the UVM guide below. So here's my contact information. Well, it looks like it got cut off, but Noelle can provide my contact information. Thank you.
Our contact information is on the last slide, so I'll leave that up at the end of the webinar so that everybody can copy that down, and they'll also get a copy of that afterwards. So thanks, Elena. All right, so I'm going to spend the last just few minutes very quickly talking about some factors that are often overlooked by farmers and landowners, yet are very important to consider when searching for the quote-unquote right farmland for you and your enterprise. Keep in mind that the right fit is very relationship-based and context-specific based on your unique enterprise. So this is more on the relationship side of things, not necessarily things that you would want to include in detail in your lease, but nonetheless very important to consider to avoid future conflicts. So production practices, and Kathy talked about this a little bit of some overview language that you might want to include in your lease, but in general, it's definitely important to communicate to any future landlord your approach to production, especially how you approach pest control, if you use any fencing, pesticides, or integrated pest management techniques, how you approach weed management, what kind of tillage you do, if you use herbicides, black plastic, mulching, and how you approach soil fertility as well, the use of cover crops, rotation, fertilizers. As an example, I've seen situations in which a landowner was very committed to organic practices, but unfortunately the farmer who's on her land was using synthetic fertilizers, definitely not consistent with organic practices. And had this issue been discussed beforehand, a conflict definitely could have been avoided. On the flip side, I've also seen landowners, or a landowner in particular, that wanted the farmer tenant on his land to use basically all of the available land for a very intensive vegetable production each year, and was not originally very supportive of the farmer letting large sections of the land rest for seasons at a time, putting them in cover crop, etc. But by having the conversation up front, the farmer and the landowner in the early stages of the negotiation were able to avoid a future conflict by coming to an agreement on the crop rotation practices from the get-go, and so that they were both on the same page and understood where each other were coming from and their concerns. Kathy also covered improvements a little bit. If you need to make infrastructure improvements to a piece of rented land, you definitely want to be sure to discuss what your desires and plans with the landowner are up front. First of all, to see if they are amenable to said changes, but also because it might be worth asking them if they would be willing to pitch in on the cost of these improvements, since it's very likely benefiting them in the long run as well, even beyond your land tenure with them. When leasing or obtaining a license for a farmland, it's a good idea to discuss with the landowner who will be on the property. So in addition to yourself, this could also include friends, family, volunteers that come help you, or other staff or employees. If it's in your plans, make sure that the landowner is comfortable with having all these people coming and going from the property. There are situations I've seen with farmers who are farming on a small plot of land, for example, next to a school or owned by a school, in which case the school required them to do or required quarry checks for all of the staff, the farmer's staff that was going to be coming onto the land. They might also want you to have some sort of additional liability insurance if there are going to be other people coming and going from the property. Especially in circumstances where your farmland is close to the landowner's home, be sure to clarify what your normal working hours are during each part of the growing season. The last thing you need when you're trying to harvest for the day's farmer's market at 6 a.m. in mid-August is a grumpy landlord asking you to keep it down or to come back later. So making sure that that's very clear up front is very important. Parking and bathrooms. So worth considering how close you're going to be able to get your vehicle to your crops, whether or not there's enough space for you to load and unload your tools, supplies, produce. Likewise, thinking about the reality of where you're going to relieve yourself and maintain sanitary practices and working on the land. Can you use a bathroom in the landlord's house? If so, this connects with the working hours I just mentioned. If not, do you need to rent a porta potty? Is the landlord okay with you renting a porta potty? Where would you put it? Is that also okay with them? So lots of details, again, that you don't necessarily want to include in the lease, but things to discuss and iron out up front. So while Massachusetts and some other states have right to farm bylaws, which basically helps protect a farmer from nuisance suits from neighbors who may complain, maintaining a positive relationship with the neighbors around your farm is obviously very critical to your long-term success within the community that you're located. If you're looking into a lease situation, be sure that your landowner has consulted with and informed nearby neighbors, especially if that land hasn't been in production recently. And once you start farming there, it's definitely worth making an effort to reach out to the neighbors to let them know what your business is all about. You never know what benefits can come out of it, what kind of connections and support they can provide to you as well. And this is a link here, just a quick shout out to the Farm Friendly Neighbor Campaign. This is a great resource online that is very user-friendly and is generated or targeted to the general public to help educate them on various different types of agricultural practices, especially with respect to how they happen in New England. So everything from nurseries to vegetable production to livestock to apiaries, etc. And this can be a great tool for you in helping communicate this to neighbors or potential landlord who hasn't farmed before. Zoning. So for those of you who are unfamiliar with this term, zoning refers to the way that a town has defined restrictions on the way that different parcels of land can be used. So uses that are allowed on a piece of land can normally be found in a table of what are called permitted uses on a town zoning website. It's important to make sure that agricultural activities are allowed on the parcel of land that you find. Things like putting up a hoop house or barn or processing and selling your products on the land may or may not be allowed in different zones. This doesn't mean, however, that a piece of land that is currently zoned in a particular way is completely set in stone. It is a very hard thing to change permanently, but sometimes you can get special permission from a town's planning board or go before a zoning board of appeals to make your case to be able to do something that's traditionally outside of a certain zone that you're looking to farm in. Other regulations referred to here that are important to research basically just includes your proximity to wetlands. You may need to get a special permit from a local conservation commission to disturb land that's close to wetlands. They may want to see a conservation plan of sorts. And another thing to research is if the town board of health has any special regulations that you're going to need to follow. Wonderful. So I think we can move on to questions. Kathy and Elena, if you want to unmute yourselves we can kind of all take the questions. So again, everyone, if you have questions, just use the chat window, and we'll take them as they come. So to start, we just have kind of a general question. What are the most common issues or conflicts you've seen come up between a farmer and landowner that could have been prevented with either a written lease versus a handshake agreement, or a better lease or better clauses in a lease? So kind of most common issues and conflicts that you guys have observed.
Do you want, can you guys hear me?
Yeah.
Well, I think Elena and I mentioned some of those. I think common comes up around the improvements and the permissions around them, and the ownership of the improvements is very common. Also, the termination provisions, I think, come up commonly, such as the example with the that Elena shared. The rent also is one that both landlords and tenants struggle with, sort of how to determine it and what form of payment, whether it's a share lease or whatever. So those are three examples of common lease snags.
I would just add to that
Elena?
too, probably equipment, like maintenance issues, and what you were going over, Kathy, of like the capital costs versus the other costs, and basically when something breaks, who needs to fix it? And if it is the landlord, by when do they need to fix it? Because just because the landlord, you know, it's written in your lease, or the landlord has orally stated, oh, I'll fix the tractor if it breaks, unless there's some duration by which they need to fix it, and then after that they have to pay you some amount of the loss of that, then that's going to be a problem.
Yeah, I agree. I think those are all pretty common issues that I've seen as well. I think the other one that I've seen, and Kathy definitely touched on this, and obviously it's a very important one, is around the termination of a lease, and under what circumstances a landowner can terminate a lease, and what kind of notice they need to give. You know, it's really, I've seen circumstances where somebody has, a landowner wanted to terminate a lease, you know, in the middle of a growing season without much notice, which really put the farmer in a very, very hard spot. And unfortunately, there really wasn't much, and in this case, it was a license agreement instead of a lease. So in license agreements, it's more of a permitted use of the land as opposed to the right to use the land. And maybe, Elena, you can talk a little bit about that. But
yeah,
unfortunately, in that situation, you know, the farmer really had no control over it, and lost a lot of their access to that crop for the rest of the season.
Yeah, just briefly, so to define those terms, a license is not a lease. A license, as you said, is when you give someone permission to use land, and a lease is when you give someone a right to use your land. And those are actually very different, because only a right is enforceable in court, whereas permission is viewed as a gift and is not enforceable. So it's actually one reason why lawyers will advise farmers, even if you've found a very benevolent landowner who wants to let you use their land for free, to actually negotiate some form of payment for that, because otherwise, if there's any confusion over whether that's a lease or a license, the courts will just look at whether or not you paid anything for it, and if you did not pay for it, they will most likely interpret it as a license.
And what kind of payment does that require? You know, quote unquote. I mean, payment?
It could be a nominal payment, but just some form of consideration, as Kathy mentioned. That's what you'd call rent, or you know, it doesn't have to be cash. It could be some of the crop, but just some sort of remuneration for the use of that land.
Mm-hmm. Thanks. And then this one's just directed to you, Elena. Do you have references to real estate lawyers, maybe a publicly available list of who might be good for farmers to approach, or is that something that they should come through the Legal Services FoodHub to get a list of?
Yeah, we don't post a list. We do post the firms that we work with on our website, but we ask that farmers come through us through the inquiry on our website or through calling us, and that we really do that work for you, because we don't want to, in order to sign up a lot of lawyers to our network, the reason they agreed to it is because we serve as that middle person so that they aren't getting swarmed with calls. But that said, often your local land trust maintains lists of attorneys that have made known that they are willing to work with farmers on lease issues.
Great. Well, it looks like those are actually all the questions that we have so far. If Kathy or Elena, you have anything else to add, feel free. Otherwise, I'm going to go to the next page here. So this is contact information for all of us. Feel free to reach out with questions. As I said, there's going to be a really brief, should take you about 2-minute evaluation that I'm going to send out once we get this the webinar published online, and we would really value your feedback if you guys have a few minutes to fill that out. So thank you so much for attending the webinar, and have a great afternoon, everyone.
Thank you.
Thanks, everyone.
Bye.